Swayam Prabha. Digital India. Educated India.
Dear students, welcome to the class of Transfer of Property Act. Today I am going to deliver lecture number 17. It is the second part of lease, and within this we will see the rights and liabilities of lessee, lessor, determination of lease and holding over. Myself, Dr. Amrendra Kumar Ajit, Assistant Professor of Law, University of Delhi. So, in last lecture, I have discussed about lease, its definition and essentials, and when and how lease is formed. That means making of lease. Now, I am going to discuss about rights and liabilities of lessor and lessee. Okay. So, I will start with it. So, according to section 108, which describes rights and liabilities of lessor. Okay. So, within that, first of all, the opening line of bare provision provides two exceptions to it. That means, if there are these two conditions, then section 108 will not apply. What are those? First of all, it is a contract between the party, that is lessor and lessee. So, if there is any contract with respect to rights and liabilities, okay, then that contract will have impact, okay, but it should not go at the same time against the provision of section 108, or it should not negate, which will fall or which will fall under the category that okay, it is against the statutory provision. So, that should not be. So, it says that these rights and liabilities which are discussed under section 108 are subject to a contract contrary or contrary to contract. That is where the lessor and lessee make an agreement to be governed by their term and condition during the subsistence of lease, their respective rights and liabilities are determined by their own agreement. Okay. Then second condition is that if there is any local custom or usage governing the rights and liabilities of lessor or lessee, then in that case that local custom will prevail and section 108 will not apply. So, these are the two primary conditions. If these are not there, then provision of 108 is going to apply. So, now I am going to show you that provision of 108, that what kinds of rights and liabilities are given to lessor. So, first of all, I am starting liabilities of lessor. So, at the beginning itself, again you should be very clear, there should not be confusion that which party is lessor and which party is lessee. Okay. Lessor is the person who is doing lease. Okay. That means lessor is the person who is the owner of the property which is going to be leased, and lessee is the person who is going to take that possession of property for the enjoyment of rights over that property. The person to whom that possession has been transferred, that person is lessee. So, here it is about the lessor, that means the person who is creating lease, the person who is the owner of the leased property, what are the liabilities of that person, that first of all I am going to discuss. So, first is about the duty of disclosure. Duty of disclosure on the part of the lessor. Okay. According to section 108 clause A, which says that the lessor is bound to disclose to the lessee any material defect in the property with reference to it, intended use of which lessor is aware, but the lessee is not aware, and which the lessee could not discover with ordinary care. This is very important, because this duty is the first duty itself of the lessor. That means, if the lessor is putting his property on lease, then whatever the inherent defect, whatever the defect which cannot be known by an ordinary person in that case, that must be disclosed to the lessee, because by apparent or by going through that property, lessee is unable to find out. Okay. So, in that case there is the duty. So, what are the material defect may fall under? The material defect is that kind of the defect, if it would have been known to the lessee, then the lessee would not have taken that property on lease. Okay. That means, the defect which is going to affect the mind of the lessee, and which is going to create a suspicion, and later on he cannot take that property for lease, those defects will be called as material defects. So, here defects are of two types. Okay. One is visible and one is invisible, one is latent, one is patent. Okay. So, latent defects are maybe material, latent defects may be material defects or may not be material defect. It is not necessary that all latent defect will be material defect. Some latent defect may become immaterial for the property. Okay. But those material defect which is going to take impact, which is going to give impact over the lessee choice, that whether he should continue with this agreement or not, whether he should go with this agreement or lease agreement or not, that type of defect will be called as material defect. Okay. So, here it has been said that the lessor is bound to disclose. It is not merely that he is not only a obligation and discretionary obligation to disclose, it is a mandatory obligation, it is a statutory obligation. If it will be not fulfilled, if there is material defect and it is not going to be disclosed, then agreement will be void. Okay. So, that is the impact of this duty of disclosure, that disclosure of material fact is a sine qua non condition before the creation of agreement of lease. So, the duty of disclosure is especially important where the defect affect the right of enjoyment and use of property. Okay. Then the duty to give possession. As we know that in case of lease, there is no transfer of ownership, there is mere transfer of possession, and possession, that is the immovable property is going to be transferred for the enjoyment of the rights over that property. So, a limited right has been transferred. So, that limited right which is going to be transferred on immovable property without the delivery of possession, that cannot be enjoyed by lessee. Okay. So, this is an important essential, I will say, in case of lease, that possession from lessor must be transferred to the lessee, so that lessee would be able to enjoy the benefit of that property. So, clause B of 108 section of Transfer of Property Act says that the lessor is bound on the lessee request to put him in possession of the property. This clause imposes a statutory obligation on the lessor to put the lessee into possession of the property leased. However, this duty of lessor to deliver possession arises only when there is a request by lessee in this respect. That means, if the lessee has not requested to deliver the possession, then lessor is also not bound at that time to deliver. But anyway, this enjoyment of lease rights cannot happen without the delivery of possession. So, anyway, whenever lessee is asking about the possession, transfer of possession, that must be done by the lessor. So, when a lessor fails to put the lessee in possession, lessee may sue him for obtaining possession. Okay. Then, in another case where the lessee has already paid rent and he may sue for the damages as well as recovering back the amount paid as rent. Okay, when the rent has been paid, but he has not got the possession of the property, then in that case what remedy will left? So, the law is that he may sue for the damages, okay, as well as for recovering back the amount paid as rent. This damages may be that because the non-delivery of the possession, he might have suffered certain damages, that will be also included here. Where the lessee gets possession of only a part of the lease property, he may repudiate this lease. That means, in lease agreement there was the whole building itself, but actually he is getting only the one part or some floor only. In that case, there will be the choice on the part of lessee that whether he want to continue or whether he want to repudiate the contract at all. So, if he is not satisfied, he may repudiate it, but question is that where he want to keep those part and started using that part, in that case he will have to pay that amount of rent or this consideration for that particular part which he is using. So, it has been said that where he wants to retain the part, he must pay rent for that occupied part. If the leased property is in possession of any third person, lessee may also sue him along with the lessor. Okay. That means, that lessor will be sued by the lessee, but also if that particular property is in possession of third party and he is not giving possession to the second one, in that case it may be sued by the that owner, that means lessor, and the third person under whom that possession is, it will be they will be sued by the lessee. It may happen that, take the example that owner has given lease of a property, one lessee is already there, it is already on the month basis. Now, it is determined, the lease has been determined, but he is not vacating it, okay, and he has already given to the second one. So, in that case there will be possibility that the second lessee can file suit against both these. Liabilities of lessor again within this itself, where the tenant vacated the premises, but did not give possession. This is a very important problem, that suppose and it is a practical problem generally used to come in life, that this lessee has already vacated, that premises has been vacated, but the whatever the security amount was paid by the lessee to the lessor, that has not been returned, and he was demanding that no, first of all return my security money, then I will hand over the key to the you, that is to the lessor. In that case what will happen? Because already premises has been already vacated by the lessee, he is only demanding that the security money must be returned, but anyway he is keeping possession, because when the key has not been delivered, that means possession was within the hand of lessee. Okay. So, in that case the Supreme Court held that if it has not been returned, key has not been returned, in that case lessee will be liable for the rent. Okay, lessee will be liable for the rent. He rented the possession whether he used the premises or not. So, he will have to pay the rent for that purpose, and for the security it has been said that there are independent remedies for that which might have been used by the lessee, but he cannot keep key with himself, and he should not say that okay, unless and until it will be not returned, he will not return the possession. So, returning of the security money is different issue, and handing over the possession to the lessor is different issue, and both should dealt apart, both should not be combined. Then covenant for quiet enjoyment, because the main transfer of possession of property in lease is for the enjoyment of the right over that property. Okay. And if that right is going to be not used properly due to some kinds of defect, because it is about the quiet enjoyment, that means for what purpose he has taken that lease. Okay, that lease property must be enjoyed properly. If there is certain deficiency in that or certain kinds of enjoyment is going to be restricted, in that case it is the duty of the lessor to provide that enjoyment to the lessee. So, it has been said that covenant for quiet enjoyment, it is a kind of promise to the lessee that whatever the property is going to be leased to the lessee, that property will be used by lessee in a proper way, and that enjoyment of use of that property is not going to be affected due to the fault of lessor. Okay. So, clause C provides that the lessor shall be deemed to contract, because he has already done a contract for the lease. So, it will be also deemed that there is a contract with the lessee, that if the lessee pay the rent reserved under the lease and perform the contracts binding on the lessee, he may hold the property during the time limited by the lease without interruption. So, there should not be any interruption in the enjoyment of property due to the fault of lessor. It is the duty of the lessor to ensure that lessee ought not be interfered with during the period of lease either by him or anyone else. So, duty is that he will not disturb, and another is that it is also duty of the lessor that if any other person is interrupting in the enjoyment of the lease, then it is the duty of lessor to restrict that. Okay. So, lessor is responsible because he is the owner of the property. He will take any action with regard to the that kind of the disturbance, and he will provide a good enjoyment of the right of that particular property. Then where the quiet enjoyment of the lessee has been interrupted, he is entitled to recover damages equivalent to the present value of the prospective profit of which he is deprived. That means if this lessee has not enjoyed the rights properly, and whatever the damage he has suffered, suppose his sleep was not good due to certain kinds of disturbance, or there is a issue related to the reading of the children, because there is a too much noise is happening which was not expected. Okay. So, that kind, suppose there is a seepage which has been not cured by the owner and the lessor here, okay, and there is damage of the property. So, all these things, because good enjoyment is the right of every lessee, and providing these amenities, that means the better enjoyment of that property is the duty of every lessor. So, lessor is bound to provide that kind of the duty, and if there is a loss of any kind of profit due to that kind of nuisance, that kind of disturbance, that kind of things which has caused damage to the rights of enjoyment of the property of the lessee, in that case lessor will be responsible for that. And this case Nagar Das versus Ahmad Khan, Bombay High Court said in that case. Then rights of lessee, because these were the liabilities, duties of lessor. Okay. Now, rights of lessee. Rights of lessee is defined within the 108. Okay. Within 108 from clause D to clause J of the section 108. Okay. What are the rights of lessee? So, first right of lessee is, because rights of lessee is what? That means he want to enjoy the property maximum. Okay. So, right to enjoy the accretion, right to avoid the lease in case of any destruction by fire or tempest, etc., right to repair the property, right to make payments, right to remove fixture made by him during tenancy, right to have the benefit of crop growing on the land planted by him, right to assign his interest in the leased property. So, these are the rights of lessee now one by one. Right to enjoy accretion. Okay. What is this accretion itself, or how this lessee is going to enjoy that accretion? Okay. So, during the tenancy period, during the continuance of lease, if any accession is made to the property, that means if any improvement is going to be made into the property, because I have already discussed in the at the time of discussing this rights and duties of mortgagor also, if you try to remember that this accession is kind of, it may be the natural or it may be the man made. So, here what we are talking about? We are talking about any kind of accretion which has been created during the tenancy, whether it is natural or man made. So, in both the cases, that lessee is entitled to use that improvement. Okay. Improvement, that means in natural, I have given the example of this, if the land near to the river was given on lease for certain years, and during the tenancy period, this due to the elevation, the area of that land has been increased. So, that increased part of the land will go with the lessee. Ownership will be always with the lessor, no problem in that, but because that area has been increased in 5, 6, 7 years, now the lessee will be entitled to use that area. In same way, if lessee is making or lessor is making any kind of construction, additional construction, which may be in the form of permanent or in temporary structure, in both these cases, lessee is able to enjoy those structure, those improvement, okay, and such accessions shall be deemed to be the comprised in the lease. That means, those improvement will be treated as part of the lease itself, whereas in actual time, that means at the time when the lease was created, those improvements were not there. Okay. But during the due course, it has been created. So, that kind of benefit of that may be taken by any lessor. Suppose take the example that in a particular flat, there was no ventilation for kitchen and all. Okay. So, owner has created ventilated kitchen, and one another bedroom was also window or balcony was open. So, in that case, because these are the things which has created later on after taking lease. So, the lessee is entitled to use those facility, and it will be treated as the part of the lease itself. Then it is done by the lessor or owner of the property. If he is doing, that means lessee is doing all these kind of things. So, certainly first of all, he will have to do all these things through permission, or if there is a contract between them. But if he is going to use with the permission, that at the time of determination of lease means just like end of the lease itself. Okay. So, at the determination of lease, he will be entitled to take all those fixtures. Okay. That means, a status quo of the property must be maintained. So, here it has been said that if there is a enjoyment of rights of with respect to accession, that must be respected, and lessee is entitled to use that. Then next is right to avoid lease. Okay. Right to avoid lease, what it is said? It is right to avoid. What is this? That means in case of fire, tempest, flood, violence of an army or mob or other irresistible force which is beyond the control of both the parties, any material part of the property is either wholly destroyed or rendered substantially and permanently unfit for the purpose of which it was given on lease, the lease shall be void at the option of lessee. Okay. That means, those kind of the circumstances which is going to frustrate the purpose of the lease, okay, then lessee will have right to repudiate those contracts, okay, because the purpose is now futile. For what purpose? Suppose there was a lease for 1 year 11 months and in between there was earthquake, and now there is no such kind of building. Fortunately, all the member of that family survived. So, in that case they cannot say that, or lessor cannot say that no, in that way, even though after this destruction of flat and destruction of complete destruction of that building in earthquake, lease will continue. That is not possible, the purpose has been completely frustrated. Okay. So, it can be repudiated on the option of lessee. Then right to repair property, this is also very controversial part, but the person who has taken lease, that is the lessee will have right to repair wear and tear. General rule is that it has been said that if the lessor neglects to make any repair which is he is bound to make to property after notice within the reasonable time, lessee may make the repairs himself and deduct expenses of such repair with interest from the rent or otherwise recover it from the lessor. Okay. That where there is a requirement of repair, generally all these things are mentioned under the lease agreement itself, that what kind of the maintenance will be done by the lessee and what kind of the maintenance is done by the lessor. Okay. So, these days it is very clear that there will be agreement. If there is no agreement, in that case what will happen? Rule is that if notice has been given about that repair and that repair has not been done, because it is the duty of the lessor to provide property in better way to maximum enjoyment of the rights related to that property. So, in that case here it has been said that if this right is going to be hampered due to the non repair, then lessee may repair that on his or her own expenses, and later on he will claim, that means he will deduct the money what has been expenditure on that particular maintenance from the rent amount with interest. Okay. So, this is the big right has been given to the lessee under Transfer of Property Act. Then right to make payments, okay. Right to make payments of it is of lessee. That means, lessee is going to give payment to the lessor on proper time. If the lessor neglects to make any payment which he is bound to make and which if not made by him is recoverable from the lessee or against the property, the lessee may make such payment himself and deduct it with interest from rent or otherwise recover it from the lessor. Right to make payments, right to make payments. So, here those payments it has been that where the lessor was entitled to pay that, but it has been not been paid by the lessor. So, sometime it may happen that there may be effect on the enjoyment of right of the property. It may be related to the electricity bill, it may be related to the gas bill, it may be related to the sewer tax, municipal tax, other kinds of taxes, if it has not been paid by the owner. So, certainly there will be gas cutting the connection of gas and electricity, it will create a problem for the lessee. So, lessee may pay that, okay, and these are the things which is going to be those things which has been not used by the lessee, because if the lessee is using and that electricity bill is coming, so that will be on the part of the lessee himself or herself, but those bills which has been used by the earlier lessee or by the owner himself, so those kind of the things will be if it is going to create problem, it may be paid by the lessee and later on the same amount with interest may be deducted from the rent. Okay. Then next is to remove fixture, right to remove fixture. So, whatever improvement has been made during the tenancy, okay, this right has been given to the lessee that after the determination of lease, okay, whatever the fixture has been fixed by lessee, that may be taken away by the lessee later on. That means, after determination of lease, termination of lease. Okay. What it says that section 108H says that the lessee may even after determination of the lease remove at the any time whilst he is in possession of the property leased out, not afterward. That means, during the possession only, even though there is a determination of lease, but if he is under the possession, he is holding the possession, so he can remove the fixtures. All things which he has attached to the earth, provided he leaves the property in the state in which he received it. That means, if he is taking away those things, doors, ceilings, fans or windows and all, so he will not keep everything in the broken state. He will have to repair all those things after taking the fixture and all. Okay. So, generally practice is that what is the cost and benefit if the fixation removing it and the maintenance later on, that means maintaining the status quo. So, status quo maintaining this expenditure is more, then generally lessee used to leave that fixtures in the that immovable property itself. But if there is a benefit, it is a very costly item and maintenance will not be as much as like the fixture, then in that case he will remove it. Then right to have benefit of crops. This is mainly with respect to the land lease. Okay. So, according to section 108I, it says that when a lease of uncertain duration becomes determined by the means except the fault of lessee, he or his legal representative is entitled to all the crops planted or sown by the lessee and growing upon the property when the lease determines, and to free ingress and egress to gather and carry them. That means, whatever has been planted on that land and in between, before cutting those things, before taking the fruit of that plants, if in between lease has been determined, then it has been said that even after determination of lease, lessee is entitled to take away the produce of the plants, and for that purpose there is requirement to come and go on the land, that must be allowed. He will be not treated as trespasser on the land. Okay. So, this right has been already given to the lessee. Then right to assign his interest, right to assign his, that means lessee interest. It says that 108J that the lessee may transfer absolutely or by way of mortgage or sublease the whole or any part of his interest, because anyway lease is not an absolute interest. Okay. So, whatever interest is with the lessee, that total interest of the lessee in that property, okay, that may be transferred to any transferee of such interest, or part may again transfer it. That means, sublease of the lease is possible. The lessee shall not by reason only of such transfer cease to be the subject of any of the liabilities attaching to the lease. That means, if he will transfer that particular lease or property to third person, not meaning thereby he will also transfer the liabilities. No, liabilities will remain attached with the lessee. Okay, that will be not transfer. Only the property may be transferred, but liabilities will be attached with that one, because he is the lessee of the lessor. So, towards lessor, liabilities will be of this lessee, and the sub lessee will have liability towards this lessor. In that way it will work. Now, after rights, liabilities of lessee. Okay. Liabilities of lessee says that within 108 itself, duty to disclose facts, liabilities of lessee. So, lessee liabilities to disclose fact. What is disclose fact? Because lessor was under duty to disclose material facts. Here lessee what he will disclose. So, he will disclose that to the lessor that any fact as to the nature and extent of the interest which the lessee is about to take, of which the lessee is aware, but the lessor is not aware, and which materially increases the value of such interest. That is important. That means, those kind of information, those kind of things which is going to increase the value of the property or increase the rights of enjoyment of the property, in that way must be communicated to the lessor if the lessor is completely unaware about it. Because sometimes it's happen that the lessor is outside of the city, lessor is in another city, he is not aware about those kind of the development which happened at the ground level there. So, whatever the things are happening, that must be communicated if it is materially increasing the value of such interest, lease interest. Okay. So, that must be disclosed by the lessee. In same way, the duty to pay rent under 108I, L, what it says that the clause L provides that the lessee is bound to pay and tender at the proper time and place the premium and the rent to the lessor or his agent in this behalf. Okay. So, whatever premium or in the form of rent, monthly rent, what has been agreed, that must be deposited on time and the place as it is determined. If it is online, it is online, if it is offline, it is offline, to whom it has been told that who will take on behalf of the lessor, to that person it must be given. Okay. So, where the lessee fails to pay the rent according to the lease deed, the lessor may sue him for arrears of rent along with the interest, or he may start ejectment proceeding on the ground of non-payment of the rent after giving proper notice. That what remedy will left with the lessor, that if the lessee is not paying the rent properly. So, it has been said that first of all he will claim about rent plus arrear and interest, as well as he may start the proceeding for the ejectment. Okay. In Abdul Wahab sub versus TV Satyapal, year 2007. Okay. Then duty to maintain the property. This is also a very important duty on the part of lessee, that where the lessee is residing or where the lessee is enjoying the rights over the land, over the property, that property must be maintained. Okay. That means, it should not be done in that way that it should not be deteriorated. Okay. So, generally it is already written in the term of lease contract itself, lease deed itself, but it is also the statutory duty on the part of lessee that he will not damage the property of the lessor, because at the time of determination he will have to return the property as it was taken from the lessor. Okay. So, it has been said that the lessee is bound to keep and on the termination of lease to restore the property in as good condition as it was when he was put into possession. So, when he entered, when he took the possession of that property, in a same way it must be returned to the this lessor. He is bound to allow the lessor and his agent at all the reasonable time during the continuance of the lease to enter upon the property and inspect it, condition and give notice of any defect in it, where such defect has been caused by any act or default on the part of the lessor or his servant or agent, he is bound to make it good within the 3 months from the such notice. Okay. So, re-entry into the that particular property is also the right of the lessor, not always, because there is a right of privacy of the lessee also. So, right of the privacy of the lessee should not be breached, but at the same time on the name of the privacy, this lessor should not be affected, his rights should not be affected. So, generally in 2 months or 3 months, one visit is permissible according to the practices. Okay. So, they can see that what is the status of my property in the hand of this lessee and how they are using it. Duty to give notice of any encroachment. The lessee is also bound, because lessor, I told you that lessor may be there, may be outside the city, may be in different country also. So, what is happening at the ground level must be communicated to the lessor. So, here it has been said under this 108N, according to this clause, if the lessee becomes aware of any proceeding to recover the property or any encroachment made upon the lessor's right or any interference with the lessor's right over such property, he is bound to give notice of such encroachment, interference to the lessor with reasonable diligence. That means, suppose some easementary right has been affected, someone has blocked the road or route up to that property, someone has created that construction that there is a restriction for air and lights. Okay. So, in all these cases, because this is going to affect the enjoyment of property, so must be aware, that means that information must be given to the lessor, and lessor will be entitled to take any action. So, at least it is the duty of the lessee to inform the lessor about all this development. Okay. Then duty to use the property in a reasonable way. Okay. This is important duty on the part of lessee, that whatever has been leased, that leased property must be used by lessee in a proper way, and its product, as a person of ordinary prudence, would use them if they were his own. He will use like his own property, and whatever the care he would have been taken as an ordinary prudence man, he would have to take care for the lesser property also. He is under duty not to use himself or allow any other person to use the property for a purpose other than for what it has been leased. Okay. So, the purpose of the lease must be fulfilled, and beyond that purpose it should not be used. So, he must not cut down the tree or sell the timber, pull down or damage the buildings belonging to the lessor or works, mines, quarries not open when the lease was granted, or commit any act which is destructive or permanently injurious to the property. So, it is the duty of lessee, first duty of lessee, that any kind of these things are happening, first of all he will inform also, and he will also not do that kind of the things which will affect the rights of enjoyment of that property. Okay. So, it is the duty of lessee that he will not do any that kind of the act if this property of lease property would have been of the lessee, and lessee would not have done, being an ordinary prudence man. So, in that way he will protect the property of the lessor. Okay. Then liabilities of lessee: duty not to erect permanent structure without lessor consent. That is also important, because these kind of the three things will come under the exception. I have already discussed it, that if lessee is constructing permanent structure for the better enjoyment of the right of lease property, then first of all there must be consent from the lessor. Even in the case of temporary structure also, there should be consent of lessor. Okay. So, the lessor must not erect any permanent structure on the property without the lessor consent, except for the agricultural purposes. Only for agriculture purposes the lessee is entitled to erect any permanent structure on the leased property, not for any other purpose. Okay. So, these are the leading case laws. Then next point is duty to retransfer property. Okay. Retransfer property here, that means duty to retransfer. Once it has been said that there is a determination of lease, the lease has been ended now, and then what will happen to the lease property. So, it says that the determination of lease after the determination of lease, the lessee is bound to put the lessor into possession of the property. Now, possession must be returned to the lessor. The property leased for a certain period of time during which the lessee is made entitled to enjoy the property. After the expiry of the term of lease, the lessee has to give possession of the property back to the lessor. He has to retransfer the property to the lessor. If he continues in possession even after the expiry of the term, his possession become unauthorized. But what is the things? This even after the determination of lease, if the lessee is under the possession of property, lessor cannot use the force. Okay, lessor cannot use the force for the eviction. He will have to take the remedy from the court for ejectment. Okay, but he cannot use the force that okay, lease is over and it is protected by the court. That even though lease is over, he cannot be overthrown by the this person lessor. Okay, he will have to take due course of law, and then only he will be entitled for his property to get back. Okay. So, that is a practical problem. Then next point is determination of lease. Okay. So, in case of determination of lease, section 111 lays down certain conditions in which there will be determination of lease. Determination means end of lease, okay, or termination of lease. So, it termination may by the act of the party, termination may by the act of the law itself, by law itself. Okay. So, first of all, according to 111A, it says that by efflux of time, where the term of lease is fixed for 1 year, 2 year, 3 year, 4 year, the lease determined after the expiry of time period automatically. Okay. The lease terminates on the last day of the time period of lease, and the lessor become entitled to take possession of leased property. Okay. Then by happening of some event, that means it provides that a lease of immovable property determines where such time is limited conditionally on the happening of some event within the deed itself. Okay, that if this will happen, then there will be termination or determination of lease by the happening of such event, it will be determined. So, where the lease contains a condition that the lease will terminate on the happening of some event, it will terminate on the happening of that event. So long as such event does not happen, the lessee will be entitled to the possession of the leased property. Okay. So, till then, if the things are not going to happen, if it is subject to certain conditions and that condition is not coming, then there will be no determination of lease. Okay. Third, termination of lessor interest in property. Termination of lessor interest, because now lessor has no right over that property. So, a lease of immovable property determines where the interest of lessor in the property terminates or his power to dispose of the same extend only to the happening of any event, by the happening of such event. Okay. Suppose take the example that a lessor was a mortgager, okay, and he has mortgaged the property, but at the same time that property was on lease also. Okay. So, once but on due course he was unable to pay the loan, and there was the foreclosure proceeding was decreed. So, in that case now the lessor had no title over that property. Okay. So, in that case now it is not going, lease is not going to continue. So, in that way it will be determination of lease by the foreclosure decree of the court. Okay. So, it may happen here under clause C. By merger. Okay. In this case it says that the lease of immovable property determines in case of interest of the lessee and the lessor in the whole of the property become vested at the same time in one person in the same right. Okay. That means whether the lessor right and lessee right has been merged into the same in that case also there will be determination of this lease. Okay. It says the lease of immovable property determines in case of interest of the lessee and the lessor in the whole of the property become vested at the same time in one person in the same right. So, that is termination of lease. Okay. Then by express surrender 11E 111E, we say that a lease of immovable property terminates by express surrender, that is to say, in case the lessee yields up his interest under the lease to the lessor by material agreement between them, that okay, we are concluding it. Then by implied surrender, it is a express surrender, another is implied surrender. Under this also a lease determined by an implied surrender, and implied surrender take place either by the creation of new relationship between the lessor and the lessee, or by relinquishment of possession by the lessee and taking over by the lessor. That means he has already surrendered the possession already got back to the lessor. In that case, it will be also treated as there is a surrender of lease and it will be treated as determined. Then forfeiture, by forfeiture. Clause G says that the lease terminated by forfeiture in the following circumstances. What are those? First, that in case lessee breaks on express condition which provide on the breach of it, the lessor may re-enter to the property. That means, term and condition of lease has been breaked, lessor will have right. In case the lessee renounces his character as such by setting up a title in the third person or by claiming title in himself, other lessee is adjudicated and insolvent, and the lease provide that the lessor may re-enter on the happening of such event, then the lessee is adjudicated as insolvent and the lease provide that the lessor may re-enter on the happening of such event. Okay. So, in that case also if lessee renounces his character as a lessee, then lessor may enter into the property and may claim it. In that way there is determination of lease. Then the lessee is adjudicated as an insolvent and the lease provide that lessor may enter on the happening of such event. This is repetition here. Determination of lease. So, on the expiration of the notice of quit under clause H, it provides that the lease of immovable property may determine on the expiration of the notice to determine the lease or to quit or of intention to quit the property leased duly given by one party to the other, and in that way there will be also treated as end of the lease. Now, next is effect of holding over. What is holding over? First of all, then effect of holding over. Holding over is there is a determination of lease is done already, and then after the lessee is in continuance of the possession of that property. Okay. So, after determination, if the lessor is continuing, the lessee is continuing the possession and lessor is taking the rent from lessee, that means there is a holding over of this lease. Okay. So, that kind of the condition only happen after determination, and here acceptance of rent by the lessor, that means both parties are agreeing that okay, it is determined, but lessee is continuing the possession and lessor is accepting the rent. So, it has been said that if the lessee or under lessee of property remains or continue in possession after the determination of lease and the lessor or his legal representative accept rents from the from the lessee or under lessee or otherwise assent to his continuing in possession, the lease is renewed from year to year or month to month according to the purpose for which it was leased under 106. Okay. That means, even after the determination by the conduct of parties, this is going to continue, that is holding over. So, what is the effect of holding over? For the application of section 116, two conditions are necessary. First, the tenant, that is the lessee, must be in the possession of the property after determination of lease, and second, the lessor or his representative must accept the rent or otherwise gives his consent to the lessee continued possession. Okay. Then it will be treated as holding over. Tenant, by holding over after the determination of lease, the lessee remains in the possession of the lease property with the consent of lessor, and he is known as tenant by holding over. The lessee will be treated as tenant by holding over. Such possession given with the consent of the lessor and is deemed to have been given for the same purpose for which the original lease was given. Okay. So, here this in that kind of things, that is a continuation of lease, but the terminology is holding over. Now, there are some terminology here. Tenant at sufferance. Okay. Tenant at sufferance means when after the determination of the lease, the tenant's lessee remains in possession of the lease property without the consent of lessor. He is known as tenant at sufferance. Okay. That means it is not holding over. In holding over, consent of lessor is important. In case of if there is no consent of lessor and this lessee is continuing the possession, then his status will be tenant at sufferance. So, possession after expiry of lease is juridical possession. When the possession of property by tenants is as tenants in sufferance, their possession will be protected by law as I told you earlier, until their eviction is done by due process, that means through the court order. That means, if lessee is saying that now I will not vacate, there is the determination, time is over, I will not vacate this property. So, he or she will be called as a tenant at sufferance, and lessor will not use the force, he will have to follow the due process. So, agreement to the contrary say that this section contains the presumption of holding over. This presumption may be excluded by the agreement to the contrary. An agreement to the contrary is an agreement which settles the term of holding over between the parties. The express agreement determines the duration and terms of the renewed lease. That means, if there is agreement within that okay, there will be no such kind of the holding over, but it will be a kind of renewal of lease. Just it happened in the case of landlord and tenant 11th month lease, okay, that after every 11th month they used to renew it. Okay. So, for that purpose this agreement itself suggests that okay, after 11th month I am going to renew it. So, it is the effect of holding over. So, in that way it is all about the rights and duties, liabilities of lessor, lessee, then determination of lease and holding over. So, it is all about it. Thank you all. Thank you so much.